Well, my presentation will be touching on these three issues. First, the changes brought in IP rights by the digital technology and internet. Afterwards, we will be touching on the new challenges for the enforcement of IP rights that derive from these new factors, from these elements. And thirdly, we will focus on the legal pillars for the protection of IP rights in this new scenario. Well, digital technology and internet have brought many changes to this field of IP rights. Here we have some points concerning this. Digital technology has given rise to new forms of IP works. What is this? Well, new manners by which creativity is expressed. Secondly, this new technology has provoked the so-called digitization of IP rights, or IP works, sorry. What does it mean? Well, the transfer of classical IP works to the digital environment. We are talking, for example, of e-books or online newspapers. This is different of the first issue. When we are talking of new forms of IP works, I am referring, for example, to holograms or new creations, new forms of creations. And here we are talking of classical works protected by copyright and that are digitized, provoking specific issues as regards or in comparison with the traditional forms of this kind of works. Let's say, for example, paper books. Third, we have the phenomenon of the migration of the intellectual property into the internet. Online activities often involve works protected by IP laws. And fourth, we have the power and the capacities of internet as a marketing tool. Internet has given rise to profound changes in the markets. We have the e-commerce. We have new commercial models unknown before. And we have a global marketplace. So any producer, any entrepreneur, any business in one place of the world can put its product and its service in another place of the world without any barrier. So we can say that this digital technology and internet offer enormous opportunities for creators, for industry, for entrepreneurs, but also give rise to challenging threats to the enforcement of IP rights. What are these challenges? Well, here we have a list of them. Digital technology allows for easier reproduction and dissemination, higher quality unauthorized copies, and greater concentration of value. Well, if you remember analog technology, you will remember that it permitted the reproduction of, for example, these cassettes, these tapes, but it was the copy was much worse than the original one. First, second, it was a physical object, so the dissemination was not so easy. And third, in fact, we had one tape of, let's say, uh, 90 minutes recording capacity. And now we have these devices, DVDs, or even memory sticks, where you can store hundreds of songs, for example. And this is an example of this digital technology applied to copyright. As regards online, the new challenges are based on some factors, like the following ones. Anonymity. This is the identity of the infringer is often unknown to the right holder. There is no means to know the identity of the person who is making an unauthorized use of your work in internet. When we refer to online IP infringement, we could compare it to the famous guacamole phenomenon. Do you remember this toy in which there are different elements popping up, and you have to um, to kick, and suddenly another stuff is popping up in another place of the board. So this is the so-called guacamole phenomenon. What am I referring to? Well, this is very simple to understand. Where a website is taken down, where an infringing website is taken down, another online listing pops up under a different URL almost instantly. So it is very difficult to track the pirate or the infringer. Another character, time sensitiveness. I am trying to emphasize that the enormous volume and velocity of online counterfeit sales, for example, make online listings very time sensitive. These listings, these infringing listings, are posted for a few days, if not for a few hours only, making tracking and tracing extremely difficult. Another factor, no borders. Internet has no border. This way, infringers typically use more than one website located in different countries. And last but not least, we are in front, or we are before, a dynamic phenomenon. The counterfeits in social media is a clear example. And here, let me read some conclusions from a report, or some conclusions, some considerations included in a report I will refer to afterwards, report to the President of the United States, dated in 2020. I will give you the title afterwards. But here we can read the following. According to a 2019 report named or titled Instagram and Counterfeiting, nearly 20% of the posts analyzed about fashion products or on Instagram feature counterfeit or illicit products. More than 50,000 Instagram accounts were identified as promoting and selling counterfeits, a 171% increase from a prior 2016 analysis. Instagram's story feature, where content disappears in 24 hours, was singled out as particularly effective for counterfeit sellers. And this is an example of the complexity of the phenomenon we are facing. In a nutshell, these new challenges can be identified as follows. First, extreme difficulties in detecting and tracking, and second, legal issues. And here we have, for example, international jurisdiction issues and enforcement of judgments issues that make the enforcement of IP rights in the era of internet quite hard. The report I was referring to earlier is this, or Combating Trafficking in Counterfeit and Pirated Goods. This is a report to the President of the United States, elaborated by the US Department of Homeland Security, dated 24 January 2020. And there you can read the following. Selling counterfeit and pirated goods through e-commerce is a highly profitable activity. Production costs are low, millions of potential customers are available online, transactions are convenient, and listing on well-branded e-commerce platforms provides an air of legitimacy. When sellers of illicit goods are in another country, they are largely outside the jurisdiction for criminal prosecution or civil liability from US law enforcement and private parties. Of course, this is predictable not only of the United States, but also of any other country in the world. What are the legal pillars for IP rights protection in this new scenario? Well, I would identify three pillars. First, new legal instruments specifically aimed at further regulating IP issues, including protection of IP online. Second, the issue of recognition of liability for intermediaries or internet services providers. We will refer to these further on as ISPs. And third, the issue of, well, I have named it as multi-jurisdictionality. Let's go into each of these questions. First, new legal instruments specifically aimed at further regulating IP issues, including protection of IP online. The previous speaker has referred to CRIPS agreement. The CRIPS agreement is today the most comprehensive multilateral agreement on IP, and as it has already said, it is a minimum standard agreement. What does it mean? Well, it means that members, this is those states who signed the agreement, are obliged to provide for the standards of protection set out in the agreement. This is, they are obliged to recognize the various rights recognized in the treaty, and in any of these and in every of these members, enforcement of rights must comply with the so-called CRIP standards. Members are allowed to provide more extensive protection if they so wish, and members are free to determine the appropriate method of implementing the provisions of the agreement within their own legal systems and practices. But in any case, they have to respect the minimum standards set up in the agreement. There is only, well, not only, there is a very important factor when we are considering the provisions of the CRIPS agreement in the framework of the scenario determined by advances in digital technology and internet. It is the question that the CRIPS agreement provisions are not online specific. The CRIPS agreement was signed before the eruption of these new developments, and therefore we have a need for new instrument focused on the issue of digital technology and internet. This gave rise to new treaties in the framework of the WIPO. This is called the WIPO Internet Treaties, the WIPO Copyright Treaty, and the WIPO Performances and Phonograms Treaty. And also gave rise to regional or bilateral instruments. For example, in the European Union, the so-called e-commerce directive dated 2000 and the directive on copyright in the digital single market dated 2019. The second pillar relates to the liability for intermediaries and internet service providers. Talking in general terms, following Angelopoulos, the ISPs can be defined as those entities that facilitate in any way the use of internet by others to access content produced by third parties. Internet intermediaries are essentially accessories to all conduct of all third parties that use their services, also infringers. This makes ISPs particularly susceptible to accessory liability. In order to put some rationale in this, because well, we cannot deny that the ESPs play a very important role in modern economy, some jurisdictions put in place the so-called safe harbor provisions. This is exemptions from liability. The conditions of these safe harbor provisions vary according to the nature of the service provided. Here we have an example. In the framework of the e-commerce directive, the mere conduit and catching safe harbors require that the ESP does not contribute to the creation of the content of the infringing content. And the exception applies even with knowledge of the infringement. Whereas, where it comes to hosting, safe harbor provisions only apply if the host, the provider, could not have knowledge of the specific infringement. So this knowledge of the specific infringement is not required for the safe harbor provisions to come into existence when we are talking of mere conduit or catching, but it is required when we are talking of hosting services. And there is no international standard. Therefore, safe harbor provisions vary between jurisdictions. Where safe harbor provisions do not apply, intermediaries may be held liable in these jurisdictions. So it means that if harbor provisions applies, the intermediary will not be found guilty. How can we characterize ISP's liability? Well, primary liability should not be excluded at all. For example, the intermediary will be found primary liable when it uses trademarks for own advertising. Well, let me make it clear that the use of the trademark is a prerequisite for considering that there has been an authorized use of trademark. Nevertheless, typically, the liability of ISPs is contributory or accessory and is based on principles of common tort law. What is quite clear is that the mere provision of physical facilities does not amount to infringement. Here we have an agreed statement to the one of the WIPO Internet treaties, stating that, and it is considered that this statement also applies to the other WIPO Internet treaty. And also here in the European Union, the European Court of Justice has established that the fact of creating the technical conditions necessary for the use of a sign and being paid for that service does not mean that the party offering the service itself uses the sign. Trying to sum it up and following Mostert and Asokan, we can identify the transnational ratio principle of intermediary responsibility as follows. Upon notice of a specific infringement, an internet service provider is required to take all proportionate and reasonable measures which a reasonable internet service provider would take in the same circumstances to address the specific instance of infringement brought to their attention. So we have the standard of the reasonable measure taken by a reasonable internet service provider. And the third pillar is that referring to the issues related to multi-jurisdictionality. Here we have two main issues. What is the jurisdiction and applicable law in the case of IP infringement on internet? Because here we have varied possible connecting factors. We have referred to the phenomenon that the infringer can act from a country in Asia, and the result of this action is shown or pops up in Europe, for example. And the second issue relates to the question of recognition and enforcement of foreign judgments. In the previous speech, this question has been pointed out as well as one of the main difficulties for the proper enforcement of IP rights. Referring to these two issues, we have to say that there are no harmonized standards globally. Therefore, in principle, these questions are resolved by reference to each country's private international law. Although in certain regions of the world, these rules have been harmonized, for example, in the European Union. This was already mentioned by the representative of the European Union, who took the word first. But even here, we have some problematic scenarios. For example, referring to jurisdiction, in general, there are two alternative fora. So the right holder, in the case of infringement, the right holder can bring actions against the infringer either before the courts of the domicile of the infringer or before the courts of the place where the violation has taken place or it is going, presumably, to take place. And with these two alternatives, it is not so rare that conflicts of jurisdiction arises.